Welcome everybody to this webinar following our Supreme Court argument on the PolyMet case. I'm Kevin Ruther, I'm MCEA's Chief Legal Officer, and with me today are Ann Cohen. Hi Ann.
Hi everybody.
Ann's our senior attorney who argued the case this morning at the Supreme Court. And then also Catherine Hoffman, our CEO. Hi Catherine.
Hello.
And we're gathered here today to basically answer your questions and talk a little bit about Ann's argument, give you an insider's look at what happened this morning. So thank you very much for being here, and thank you also for being one of our important donors. You received this invitation because of your support of MCEA. Your donations make our work possible, and we're very, very grateful for that. We couldn't be doing this work without you. We're going to be using the question and answer function on WebEx. So if you take your cursor and you hover over the screen, you should see a little bubble box right in the middle at the bottom that says Q&A. If you click on there, you can type in your questions, and I'll sort of be paying attention to the questions and asking for answers from our participants today. But I wanted to start just by congratulating Ann. Way to go. Nice work, Ann. How are
Thank you.
doing? What's it like to be over this hurdle?
Well, it is definitely a milestone. So in preparation for this webinar, I actually went back and I looked through the pleadings files that we have on this case. And we just got done with the, last act, hopefully, at the Supreme Court. And in that file, there are 64 documents, and briefs, and more, and people entering their appearances, and etc. But there are 64 documents there. I went and I looked at the Court of Appeals file. There are 230 documents in the Court of Appeals files: briefs, motions, supporting declarations, primary briefs, response briefs, reply briefs, replies to motions. I estimate that I wrote over 1,000 pages, I think, of legal argument getting this case to the Supreme Court. So yeah, it's a milestone.
Wow, yes, a milestone. I'm guessing you must feel exhausted?
I feel a little exhausted, and I'm feeling very glad that this stage is over. And I'm looking forward to helping my colleagues at MCEA with their next PolyMet events, including the one coming up next month, where Evan Mulholland and I have worked very, very closely on that appeal. But he gets to do the argument, so he's in the hot seat.
Yeah, well, it's always nice to have an argument over. That adrenaline rush done, and then you can kind of relax for a few days. So tell people a little bit about the case. I'm guessing that a lot of folks who are on the webinar maybe watched the argument. Certainly they know about PolyMet and all of our cases. This particular case was about the permit to mine. So what were the more specific issues that the court had to wrestle with today? Well,
we were defending, as people know, our victory at the Court of Appeals. And what the Court of Appeals decided to do was to send the PolyMet case back to DNR for what's called a contested case hearing. And I can go into a little bit more about that later. But that was the main issue before the court, whether we had a right or an entitlement to a contested case hearing. But there was a second very important issue in the case, and that's also whether DNR was required by law to establish a fixed term for this permit, which it declined to do. And we believe that that issue was intrinsically connected to what is another thing that we feel DNR did illegally when it issued this permit, which was authorize what's called a wet closure, which goes on and on and on and is never finished. And we said to the Court of Appeals and to the Supreme Court, that is not reclamation.
Okay,
that reclamation is required.
We can come back to some of those specific issues. I think that people are going to have questions about them. But I wanted Catherine to talk with you a little bit about MCEA's mining work And I don't know if people will know that actually before you became our CEO, you were actually managing all of MCEA's mining work and had done your own thousands of pages probably of drafting on the PolyMet proposal since it's been around for so long. So maybe you could kind of set this into some context. Give people a sense of all the work that went into getting this case in front of the Supreme Court.
Yeah, so I joined MCEA in 2010, in December of 2010. So I'm coming right up on my 10-year anniversary, and this was my case. And this was also, by the way, a time when MCEA had 3 lawyers, I think. It's just you and me and Beth.
Wow.
So, you know, there was no team to manage. There was no, like, you know, it was just me writing some stuff. But there was, at that time, PolyMet had just released their first draft of the EIS and been told, specifically by EPA, it's not good enough, you have to do better. And I should say DNR released the EIS for PolyMet's mine. And so they went back and started over and released a new draft in like late 2013 with a comment period into 2014. So during those years, what I did was spend a lot of time reading and learning about the mine, and also writing our comments, and they were hundreds of pages, and getting the experts together. So a lot of the experts that were talked about in the argument this morning, and their reports were part of the record that MCEA and our clients put in, were experts that I recruited, you know, almost 10 years ago, and have worked with us through the years. And I was particularly struck by the consistency of it. I mean, many of the concerns that we raised 10 years ago remain concerns today. They've never been addressed or meaningfully, I think, engaged on by the agencies. And so, you know, it's amazing to me that 10 years later, we're still saying the same problems with the mine, and our experts are still raising the same concerns, and they still haven't been resolved.
Yeah, it's kind of cool that we're finally saying them to people who can make a difference, those 7 justices this morning. And I was really impressed with how engaged they were and how familiar they were with the record, especially given the enormous size of the record. I can't even imagine being one of their clerks.
Yeah.
And we already have a question. You mentioned that one of the issues is whether or not we can have a contested case hearing. Can you describe what a contested case hearing is, why that's important, particularly in this case?
Sure. A contested case hearing, just in short, is an administrative trial. And when I worked for the state of Minnesota at representing the Minnesota Pollution Control Agency, I did a lot of these. And these trials take place at a separate agency, which is not under the control of the Pollution Control Agency. And that agency is called the Office of Administrative Hearings. And it has what's called administrative law judges. So when an agency is either legally required, or sometimes when it's right to do so under a discretionary statute, you know, that says, well, you can send this to hearing if you find these things, which is exactly what we have for DNR. The agencies will send a matter over to this administrative law judge, so the administrative law judge can find the facts. And this happens in a trial that looks like it comes right out of TV, all the TV trials you've seen. It's not very different at OEH. There are witnesses, there's cross-examination, there's documents entered into the hearing record. And the only difference is at the end of the process, when the judge decides the case, in this case, the decision is a recommendation, and it goes back to the agency, and the agency itself looks at the record and the findings and the conclusions of the administrative law judge, but then gets to make its own decision. So that's the main difference.
Okay, cool. We have another question. Catherine, maybe you can answer this one. What does EIS stand for? What is it? We use a lot of acronyms in environmental law, so apologies.
Yes.
They kind of slip out of your mouth without even recognizing that they're coming. So an EIS.
Yeah, my bad. That is an environmental impact statement. And it's a form of environmental review under the Minnesota Environmental Policy Act, and also the federal equivalent, which is the National Environmental Policy Act. And you've probably heard these acronyms. NEPA is the federal one. And then we have our own state level one, which is referred to as NEPA. And what these laws require is that an agency has to study the environmental impacts of a project before starting it. And the law is very clear. Like, you have to finish the study and approve it before you can start giving permits or other types of approvals to the project. And PolyMet's EIS took a long time, and a big reason for this is because the first draft was not particularly, it had a lot of problems. So for example, there was an issue of, they would dig a mine pit, and then because in Minnesota we have more rain and snow than evaporation, over time that mine pit fills up with water and just overflows. And the water that comes out of there is polluted. And there was no strategy for dealing with that. They just said, well, that might be a problem someday, yeah. And that was the way the first version handled it. And the Environmental Protection Agency said, this really isn't good enough. Like, this is going to be a clear violation of the Clean Water Act. You have to manage it. And so then PolyMet came up with these strategies of, basically collecting and treating the water forever if necessary. And so those are the kinds of things that environmental impact statements are designed to figure out before you've even started constructing the project, so you can make the project as environmentally sound as possible.
Great. So I want to go back to the argument itself a little bit, and I wish that there were a way on WebEx so that I could have people raise their hands if they were able to watch it. If you weren't able to, you can go back and watch the recording of it on the Minnesota Supreme Court's website. And I thought it was really fascinating. There were some great moments and great questions by the justices, but I wanted to get your guys' reaction. So, Anne, what did you think?
Well, I thought the argument went well for us in general. In particular, I can see we have also a question about bentonite coming up. And in particular, it was clear that the court had really looked at our brief when it came to this issue. Now, what the DNR is proposing is to take this type of clay and mix it with tailings, a very low percentage of this clay, 3%, and mix it with tailings, and essentially cover the entirety of the 1,400-acre tailings basin with this clay in order to protect from acid mine drainage development. And all of our experts, and indeed all of DNR's experts, said that this wasn't going to work. And so it was clear in the argument, I had put all this into a table form, and it was very clear that Justice Hudson had felt that the table showed that DNR did not have substantial information in its record. So I thought that went very well for us. It wasn't clear otherwise really whether the judges were buying into the argument that the contested case issue is really an issue separate from the issuance of a permit, but it seemed like at least some of them were understanding that argument.
Yeah. How about you, Catherine? Any takeaways?
Well, I was also struck, like Anne, about how well the justices knew the record, which I think is encouraging, and that's good. There was an exchange right at the end of the argument. So the way these are structured is the party that appeals gets to go first and last. So since we won at the Court of Appeals, the mining company and the DNR were the ones that appealed. So they got to go first and last, which is, I think, a little frustrating, but it's the way the rules go. And I was struck at the end, there was an exchange between PolyMet's attorney and some of the justices about whether DNR is a neutral decision maker. And they were sort of referring to DNR as the neutral arbiter, and they're the ones that weigh the evidence and make a decision. But I think in our assessment, there have been a lot of problems with the agencies, the way they've handled these permits over the years. And to us, they don't come across as neutral decision makers. And DNR in particular, they're supposed to issue these permits, but they're also under statute, they're supposed to promote mineral exploration. So their clear statutory duty is in favor of permitting this mine and having it go forward. So when we talk about neutral arbiter, we talk about like the administrative law judge that Ann mentioned in a contested case hearing. And when PolyMet talks about it, they talk about DNR, and that's a big difference.
You sort of commented on this, but we have a question. How do you think the court was receiving your testimony this morning?
Well, in general, the format is really kind of tough, I have to say. I mean, we have to wait our turn. And then the way this works on the WebEx, even though there are 3 different parties arguing, only the first party, which in this case was Water Legacy, got to make a statement. And so, it's really hard to read the court when the court is just asking questions and you're trying to answer them. Having said that, I thought some of the justices asked some really good questions, and some of them, in particular, Justice Moore had picked up on a point that one of our amici, and amici are friends of the court, had made in their brief. And we had organized this brief, which was 2 administrative law judges and another party who is very experienced in administrative law. And they pointed out in their brief that it was very speculative for the DNR to say that a contested case hearing wouldn't help it. And it was nice to see the court heard that argument, clearly had read the briefs of these administrative law judges, or they're retired now, obviously, but clearly had read their briefs. So I think there was some receptivity there.
That's great. That's an interesting point, because I also heard mention of the other amicus brief, or one of the other amicus briefs that we had organized, the one on financial assurance. Was it Justice Chudich who was asking about that?
I think so. So it's clear, and maybe it's a great time to say thank you to those people who helped us out with this case, because it was clear that the court had paid attention to what was said in those briefs.
Yeah.
Yeah.
Here's a question.
Say, Kevin, before we move on, I was just going to add one thing I noticed that was a limitation of this format was, I think it was a combination. One is just being remote, but the other is that there were 5 lawyers in this argument, which did break up the time quite a bit. And I think it made it harder to see that give and take between the justices and the lawyers, and whether the lawyers' arguments are really landing. And I'm just contrasting it with, last week we were at the Supreme Court also on a fracked gas plant. And in that case, there were 2 lawyers. And I thought, the advantage of that being that it seemed like they were able to engage and have a little bit more give and take. Whereas here there was a lot of, as soon as they dug into something, it was the next lawyer's turn. And it was harder to gauge where the justices were, I thought.
Yeah. It also seemed sort of odd the way that the justices went through with their questions. And then during the respondents' time, so when MCEA and Water Legacy and the band went, the justices actually seemed to be out of questions by the time we got to the band's lawyer. I don't know if you have thoughts about that, but she was able to just present for her 5 minutes of argument.
Yeah, that was really nice for her. And, being sandwiched in the middle, was really unfortunately the awkward position. And we didn't realize going into the case that the court didn't give each party a brief time to speak. That rule was only made clear to us later. And so that made it really challenging. It's a very challenging format. I don't know why the court has chosen to do it this way. Just give one party the statement, but that's their decision. There's nothing we can do about it.
Yeah. Here's a question about what happens next. What is the timeline for a decision, and if the decision is favorable for an administrative law judge hearing?
Well, so the Supreme Court typically will take a fairly long time to write its opinions, and easily 6 months would be a typical time. Now, I don't know whether they feel compelled to rush this for some reason. Hopefully not. So I don't expect to see an opinion from the court until maybe early next spring. And then if we get the contested case hearing, then the first thing that DNR will need to do is decide on the issues that it wants to have a contested case hearing on, because that is its decision, and the Court of Appeals actually acknowledged that. The Court of Appeals suggested, issues that were appropriate to hearing, and so DNR probably better keep those issues as part of the hearing. But at any rate, DNR will issue a notice and order for hearing, and they'll hold a pre-hearing conference. And this will take a matter of months before the hearing at the Office of Administrative Hearings actually gets going. So we're looking there at another 6 months.
Catherine, maybe you can talk a little bit about, looking at MCEA's work broadly. How much are we dedicating ourselves to PolyMet, and how many resources has this really taken for us over time, and especially now when we have all these active cases?
Yeah, I mean, it is a lot of resources. Going to the Supreme Court is a lot of resources, because in addition to having, 1 or 2 lawyers who are writing the brief, we need folks who help with proofreading, and not just proofreading, because they're not really just looking for typos. I mean, you need other lawyers to sort of look at the strategy, right? You want other opinions, and folks say, yeah, is this our strongest argument, or is this our strongest argument? Should we devote more time here? Those kinds of questions. And then there's all of the final sort of putting the brief in the shape that it needs to be for filing, which is also resource intensive. At one time, MCEA only had 1 paralegal, legal admin support staff. Now we're up to 2, which is helpful, but those folks play a really important role in the filing of all of these documents. And so, I mean, for sure at this moment in time, it's a good chunk of our resources. MCEA has also grown. So we have a lot more lawyers, not the 3 that we used to have when I was first hired, but I think we're going to be up to maybe 8 litigators soon. And so we are able to do other things also, but we don't want to take any resources away from PolyMet. I mean, one of my frustrations watching this case, we hear a lot about, oh, this has taken forever. The agencies it's taken decades, and this must be very thorough. And I think the reality is that the agencies have spent decades in part trying to justify their way out of these issues rather than having open conversations. So if we'd had, it's true, contested case hearings take a while. They can take anywhere from 6 to 18 months, depending on various factors. It's also true that if DNR had agreed to one in the first place, all of this would have been done years ago, right? Like, this is not, and some agencies like the Public Utilities Commission hold a lot of these contested case hearings really as a matter of course, because they find it to be a useful tool to, get all the evidence out. And so, I think this case is going to continue to take a lot of our resources, and litigation is never the most efficient way for us to resolve stuff. There could have been better ways, but the agencies were never open to it. And so here we are, us and the taxpayers and PolyMet all putting millions of dollars into this case because we didn't have a contested case hearing years ago. So,
yeah, and just
that's
sort of following up on that, on the contested case piece and the resources, if we are successful at achieving a contested case, that's also going to take a lot of resources. As Anne was describing earlier, it's really an administrative trial. That means flying all of our experts here, prepping them, paying for their hotels, getting all of their cross-examination ready for the other witnesses. I mean, a trial is going to be super resource intensive, and it's going to take a lot more than just one attorney working on our side to get it done and do it successfully. So we are hopeful that that's going to happen, that we're going to win this and get that contested case so that we can get to the truth about PolyMet. We also know that it's going to really require us to put together a lot of resources.
Yeah, I mean, it could easily be $1 million just on our, between the attorney time and the cost of the experts. A 6 to 18 month contested case hearing could easily be $1 million for MCEA.
Yeah. There's a specific question about the contested case hearings in NSP and Owatonna. So those are, Owatonna was a Minnesota Court of Appeals case, and NSP was a Supreme Court case dealing with contested case hearings. The person is asking, what was that about?
Well, the NSP case, I can speak to that. There were a whole series of cases that were brought at about that time, the late 1980s and the early 1990s, and they concerned the development of what's called a waste-to-energy plant, where you are burning garbage and you are getting the thermal value out of that garbage, because garbage burns well, frankly. It has a lot of energy in it because we have a lot of paper and we have a lot of plastics. But there are a lot of pollutants that come out of burning garbage, and these pollutants go into the air and the pollutants go into the ash. And so there was a whole series of cases in the late 1990s where people were challenging these waste-to-energy plants. So the NSP case was one of those cases, and I think that was specific to the ash landfill. And at that time, very similar to DNR, PCA, the Pollution Control Agency, did not have landfill standards. So this was a really hard thing. People were asking for permits when there really weren't very good standards. Now we don't have those cases anymore because the PCA has adopted some very thorough rules. But anyway, at that time, there were citizen groups just like MCEA's clients who were asking for contested case hearings, and the agency was turning them down. But these citizen groups, unlike MCEA, they didn't come armed to the hilt with expert reports and scientific evidence. Some of them wanted the hearing to basically explore for evidence as to whether the plant was good or not. And the court struck those down. And so today, in the PolyMet case, we are asking the court to say, well, look, you turned those people down in the 1990s because they didn't come with expert reports and they didn't come with scientific evidence. Well, here we are. We do have expert reports. We do have scientific evidence. Therefore, we should get a contested case hearing. And we'll see what happens on that. The Owatonna case was a water case. It involved phosphorus levels and leading to eutrophication in certain waters and modeling and et cetera. And I believe MCEA, which was the plaintiff party in that case, did have an expert, get a contested case. And then what happened there is it got settled. The agency and MCEA managed to find common ground and settle that case, which is also a frequent outcome of contested case petitions.
Why is that not happening here?
That is an excellent question. And I mean, maybe DNR realizes that, frankly, not many of these issues could be compromised in a way that would leave people happy. I think it's fair to say that some people feel, because frankly, it's never been done, that in no way, no how will this mine not lead eventually to pollution of our natural resources and frankly, costs to the taxpayers. So maybe we don't have that room for compromise there.
I thought it was interesting towards the end of the argument, we had been suggesting that a contested case hearing will increase public trust because all of these issues will be aired and you'll get to hear from each expert. And I think it was PolyMet's lawyer who made the opposite argument, saying that if the court overrides DNR's decision, they're really going to create erosion of public trust in the agency. What do you guys make of that argument?
I mean, I don't think that's fully grounded in the reality of this mine and its history. I don't think that DNR has earned the public's trust in this case. And so I don't think that they, it's not theirs to lose. So in a way, I think it's their job at this point to think about, well, what can we do to earn the public's trust back and say, okay, we are taking this seriously, we are listening to these experts and we're weighing them, and we're not just taking the side of the mining companies, which is, what it looks like when they're appearing on the same side of the mining companies in every single one of these pieces of litigation. And that a contested case hearing would give the DNR the chance to kind of hit the reset button and say, okay, we're going to start over here. We're going to listen to the experts on both sides and see the facts, and then we're going to make a decision based on all of this information. I think it would help them. It would be a big step towards earning the public's trust again if they agreed to it.
And if I can pop in on this, I mean, you know, from a litigation perspective, the very first finding that DNR adopted in support of its decision to issue this permit said, and incorrectly so, that DNR had been given the authority to issue permits to mining companies in order to promote mining, not protect natural resources, but to promote mining. So they look at this permit as a permission slip. They don't look at it as a tool to protect the public. And they see their duty in maybe an unbalanced way. They see they have their thumb on the scale because they see their duty is to promote mining, to promote this as an economic activity. Right. And that's very troubling.
Yeah. There's a good question here. We were talking about how many resources this has taken and will continue to take. The questioner is asking about our efforts to coordinate with others who are working on the same issue, like Paula at Water Legacy or Center for Biological Diversity, Friends of the Boundary Waters, which is our client in your case, and maybe we can talk a little bit about those efforts. There's definitely a lot of coordination and collaboration that's going on.
Absolutely. We're stronger together than we are separately. And, you know, one of the great challenges is that we all are independent. I mean, I can't tell Water Legacy what to do, and Water Legacy can't tell me what to do, and Fond du Lac has its own ideas or what's important. And so one of the hidden costs, if you were, of this kind of litigation is the time we spend coordinating with our allies to make sure that we aren't crosswise with one another, because nothing undermines your case more than being crosswise with the people that you're theoretically on the same side with. Yeah.
And Catherine, maybe you can talk about how we've been developing those relationships for years and years.
Yeah, you know, historically there have been regular meetings, monthly meetings of most of or all of the nonprofit advocates that work on mining and really sulfide mining as an issue. And those have been going back more than a decade. And those have been useful. Now they're not necessarily litigation focused because, you know, for years there was no litigation. It was just preparing for the environmental impact statement and comments and political strategies as well. But those monthly meetings really increase the information sharing and transparency between the groups so that at least we all know what each other is doing, even if we don't always share the same goals. You know, today I would say these different groups that are involved each have a little bit of a different role, which I think does make us stronger together. You know, so Friends of the Boundary Waters tends to bring, they have a lot of engagement with members around a specific place, which can be very powerful in its leverage. You know, Center for Biological Diversity is a national group, so they bring some connections there. And MCEA's niche, if you will, is that we have all of these in-house lawyers. So we have our team of litigators. Other groups, Water Legacy does have the one staff attorney in Paula, but we have a fairly large staff at this point, and that does allow us to leverage those in-house resources, not necessarily rely on volunteers or other things. So that's kind of what makes us unique within the various groups. And it also means that realistically, when it comes to a contested case hearing, MCEA is going to be putting a lot of the resources in because we do have the biggest team of litigators.
I just want to invite people again to put your questions into the Q&A. You'll see little bubbles down at the bottom of your screen if you hover over there, and we'll try to get to your questions. There's a question here about the oral argument. Somebody was paying attention and noticed that Justice Thiessen was absent. I don't know if we have a good answer, but he recused himself apparently. Anybody want to speculate as to why, or maybe explain recusal?
Well, recusal is where a judge has a conflict of interest. And typically it would be a situation where the judge has a relationship with one of the parties. So one of the parties or one of the parties' counsel has a family relationship or something of that nature. Or, for example, when before the judge was a judge, he worked extensively and represented a particular party, such that the judge could be seen as biased. We have no idea why. It was a surprise. In fact, I think it was almost a surprise to the court itself, because right before the arguments started, I got a call from the chief clerk saying, "Oh, by the way, we just learned that Judge Thiessen is going to be recusing himself, so you won't see him on the WebEx." And, like, okay,
Yeah,
fine.
I was very surprised by that. I don't know what it would be. And I had a question. Do you remember when the statute was amended that changed the standing requirement for getting a contested case? Was it
Well,
when he was the speaker?
It was in 2017. I don't know whether he was the speaker then. But really I have to say was one of our points to the court. The standard has really not changed. There was originally a statute, it called it objection and not petition, but it really was about the same thing. And then DNR's rules provided for a contested case hearing. And so really not that much changed when this 2017 statute was adopted. They may have thought they had changed something, but as it turns out, it doesn't look like they really did.
Yeah, it's an interesting question. Here's one about twin metals. Is it something that MCEA is also grappling with? Does it present many of the same problems as PolyMet? Catherine, what do you say about twin metals?
Yes, and yes, is what I would say. Yep, so MCEA's lawyers and experts have been digging into the twin metals proposal the same way that I did 10 years ago on PolyMet, and that's about the place where twin metals is in terms of the process. So there's a lot we don't know about that proposal, a lot of details that have not been either announced or maybe not decided by the mining company. So it's early. There are some design differences, but the fundamental issue remains the same, which is that copper nickel mining as an industry has a very poor record. There aren't really good examples of clean mines. And so we are, allowing this, and maybe this is the first one, but is that the kind of experimentation we want to have right next to Lake Superior or right next to the Boundary Waters? So those are the same fundamental questions. And I think, big picture, in a way, like everything we've done up until this point and will continue to do on PolyMet, we are also thinking about twin metals. And we're thinking about tech, and we're thinking about other proposals that are out there, because there's a bunch of them. And the reason that we're throwing so much of our resources at PolyMet is because these statutes and these rules that Anne argued about in court this morning have never been interpreted or applied before in many cases. Many of them are specific to copper nickel mining, and how they're interpreted now is how they'll be applied to every other mine. So this precedent that we're setting on PolyMet is hugely important for the future of the mining industry here in Minnesota, and it's why the first time we interpret it is in many ways the most important. So we want to make sure that we have our laws interpreted in the strongest possible way the first time.
Yeah. If we get a contested case for PolyMet, we'll be getting a contested case for twin metals.
Yes, most likely that is true.
There's a question about coordinating with groups in southeastern Minnesota who oppose copper nickel mining.
That's more the frack sand area.
We would certainly welcome the opportunity to coordinate with those groups. Off the top of my head, I can't think of whether we've had any groups from southeastern Minnesota express interest in that issue. Do you guys remember?
Not as groups as such. I mean, I think one of the things that we did early on here that has today proven to be really helpful was put some resources into raising awareness around this issue. So we formed the Mining Truth Coalition in 2013, 2012. with the Friends of the Boundary Waters and with Conservation Minnesota. And the goal of that was really to make more Minnesotans aware that copper nickel mining proposals were happening and that they're different than iron mining. And so we traveled all over the state to editorial boards and places like that. And I remember going to some in the southeastern part of the state. And it was helpful because it really did remind folks that this isn't just an issue for people on the range, that this is a statewide issue, that all Minnesota taxpayers are at risk in the event of a collapse or a problem, that we all are invested in having clean water and strong laws. And so I think having some of those newspapers weigh in at the time was really powerful. But I'm not aware of like nonprofit groups that we partner with from there.
Okay. Question about the process here. Would the court ask litigators for some additional written clarification after today's argument?
So maybe I can take that one. In general, no. From time to time, the court will ask for additional briefing if an issue came up that sort of surprised the parties, or the court thinks of an issue that wasn't really well briefed by the parties. So that happens very, very rarely, and I don't anticipate it happening in this case. Now, what you did hear today, if you listen to the oral argument, is the fact that DNR was missing a key document from its compendious 700,000 page record. And we had identified, this study as, being, just a reference to the study, not even the study itself, as being, the sole source of information supporting DNR's bentonite proposal. And the court recognized that that document wasn't even the record. And you heard DNR's attorney saying, well, we can submit it. We can submit it. And that would be totally improper. So if DNR does try to submit it later, we will submit a letter objecting strongly to DNR's after the fact submittal of the study, which they didn't include in their 700,000 page record.
Yeah, I thought that was just crazy that their attorney was suggesting that they were going to submit it at this point. Maybe you can explain a little bit who that attorney is, that he's not representing the Minnesota Attorney General's office.
He is not from the Minnesota Attorney General's office. DNR in 2015 asked permission from the state attorney general at that time, Lori Swanson, to appoint private counsel to represent the DNR. And of course, that was a great gift to the politician, Lori Swanson, because she didn't have to deal with this very difficult issue. And so that permission was granted, and the firm that DNR hired, originally it was called Crowell and Mooring, and now it's called Holland and Hart. But the firm is a firm that typically represents mining companies. And at that time, MCEA, and this document, interestingly enough, is in the record, objected to DNR hiring basically a law firm that typically represents mining companies because this seemed biased. And you would normally want a state agency, if it hires a law firm to help it with a decision, to hire one that would be more balanced and could represent the public interest in the same way the Attorney General's office would represent the public interest. But that is not what happened here.
Oh, here's a question comment from somebody who's smarter than us, I think, suggesting that maybe Justice Thiessen recused himself because he's on the ballot, because he's a challenger for his position this year. That could be. And also about the hired attorneys, we have an interesting question. So if and when Glencore PolyMet loses, is there any way for the taxpayers of Minnesota to seek remedy for the millions of dollars they've been forced to pay for the DNR attorneys to work on behalf of Glencore PolyMet to poison our water? Can Glencore be forced to reimburse the state of Minnesota for what they've cost the taxpayers to defend their mine?
And
I'm going to say sadly no. I will say no. I can guarantee that if the Attorney General's office had hired attorneys to handle this case, it would have been a lot cheaper. I know that for sure. So, when a company does, when a state does an environmental impact statement, then the law provides that the company which is being, the proposal is being examined in the environmental impact statement, they have to pay for that, but not for the litigation to support the permit. Once the state agency makes a decision to issue a permit, then it's the taxpayers that defend that decision.
Yeah. It always, the outside counsel situation also always struck me as odd, because the Attorney General's office is going to have to do more litigation on mining in the future. And so I think at the time there was this notion that if you hired these mining attorneys, you would get some expertise, which is actually a bit questionable because they weren't Minnesota lawyers, and a lot of these questions are about Minnesota mining law. But regardless, you know, you've basically invested in outside lawyers to gain the expertise in Minnesota mining law. And if they have to litigate in the future over other mines, you've left a hole at the AG's office in terms of experience. So it always struck me that having Minnesota Attorney General, you know, assistant attorney generals represent the agency made sense, not only financially, because it's a lot cheaper than paying the hourly rate of these big firms, but also just in terms of, you know, as a long-term strategy for the management of the office.
There's a couple other really quick questions here, and then I think we probably have to wrap, given that we're taking up people's lunch hours. The first is about whether Trump's pledge to fast-track mining permits could potentially affect the PolyMet proposal. Maybe I'll just quickly say that luckily we have state laws here that are not impacted by Trump's pledge. I would say that with twin metals, it is having an effect on the way that the federal government is going about studying and regulating that proposal. And so the BLM is probably going to be required to fast track the environmental review. But as Catherine was mentioning earlier, we have state laws that require environmental review and state permitting requirements. None of that will be affected by, or should be affected by the federal law. And then a second.
Kevin, can I just add one more thing about that real quick, which is that that strategy has actually backfired, or looks like it might backfire a little bit, in that in PolyMet, the state and federal agencies work together in one big environmental review study. And in twin metals, one risk of this is that the feds will do their own like fast track study, but it doesn't look like the state wants to be part of a fast track study. So they may end up actually doing two separate studies, which is probably going to take longer and be more expensive for the company.
Yeah, good
it
point.
might also mean we end up litigating in federal court and then in state court.
Right. And then finally, is the outcome of the PolyMet case likely to have any impact in Wisconsin? It's kind of an interesting question. What do you guys think?
You know, there were some copper nickel mines in Wisconsin that have been brought up as examples. They were very different. They were underground mines. They were very limited. In fact, in one, they shipped the ore to a different location to be processed, and still they caused pollution.
Yeah.
So those are done deals. I don't know where Wisconsin is at. I think that was in Michigan, actually. So I don't know where Wisconsin is at with regard to.
Eagle Mine in Michigan. Wisconsin had a big proposal for a taconite mine a few years ago. GTAC, I think it's Gogebic. I never know how to say that word. Gogebic, taconite. But that one turned out to be a little bit of, it was a very underdeveloped proposal. There wasn't enough information about it really to make it go forward. And so I don't know that Wisconsin has a copper nickel mine moving forward that I'm aware of, but regardless, it's not super clear because our laws, this is mostly decided under state law, which would be different in Wisconsin.
Yeah, great. Well, I think that we want to thank folks for being here, and Catherine, maybe I'll give you the last word.
Sure. Well, as we've mentioned, we have devoted enormous amounts of time and resource to opposing PolyMet's dangerous sulfide mining proposals. It's really critical that Minnesota gets this one right, and we're counting on you to help us continue to fight. So we'll be back in front of the Minnesota Supreme Court a month from now, challenging PolyMet's air permit, and we'll have a similar webinar to this as well, by the way, so watch for that. And in the months that follow, we'll be asking the courts to also reject PolyMet's water permit, which was in district court. Now it's going to be at the Court of Appeals soon. And that one does not adequately protect Minnesota's waters. So we can't do any of this work without your support. In particular, on mining issues, there aren't a lot of foundations that support our work. There's a few, and we're very grateful for them, but it's less common than for our other areas of work on climate and agriculture. And so we really count on individual donors to do the mining work. So I invite your continued support today. So if you were moved by what you saw today, if you believe that this is important work, please go to mncenter.org today and make a donation. We're entering our end of the year push, so now is a really great time to do it. And thank you so much for supporting MCEA. We're very grateful.
Thanks, everybody. Thanks for watching.
Thanks all.